This video is for informational purposes only and is not intended to be legal advice.
Hi, I'm Joseph Lavelle, and I am the founder of Dynamic Legal Solutions, LLC, and also the principal attorney of Navigate Legal Services, LLC. Here's an article I wrote called The 3 Things You Must Know Before Starting Your Divorce in Oregon. Before filing a divorce petition and other initiating forms with your local county courthouse, there are certain requirements that must be met or your divorce could be rejected or vacated. 1. The residence/domicile requirements must be satisfied. Before you file a divorce in Oregon, you or your spouse must have lived in Oregon for at least 6 months continuously before you file the divorce petition and other initiating forms with the court. The 6-month requirement does not apply, however, for a petition of separation. Additionally, the divorce petition and other initiating forms must be filed in a county in which one of the parties resides. This could be relevant to your situation. For example, if you moved around Oregon and a bordering city back and forth, fled a domestic violence situation, or otherwise moved to seek stability. Living in Oregon means you are domiciled in Oregon, i.e., residing in an established home or abode in Oregon with the intent to continue living in Oregon for the time being. If you meet the residential requirements, you can file your divorce petition immediately. If you are approaching the 6-month requirement, you can get your forms prepared in advance so that you can file for divorce at the earliest time possible to avoid the possibility of your spouse filing in the state or county they reside in and possibly having the divorce case heard there. You can see why this would be important because it would be very inconvenient to have to travel to another city or county, or even worse, another state to do the divorce. Number 2, child custody jurisdictional requirements must be met. For an Oregon court to have jurisdiction over issues involving any child, such as custody and parenting time, the requirements of the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, must be met. For Oregon to have jurisdiction, the UCCJEA requires Oregon to be the child's home state when the divorce is initially filed or was the child's home state within 6 months of the initial filing, and at least one parent still resides in Oregon. Oregon is considered the child's home state if 1. The child has lived in Oregon with the parent for at least 6 consecutive months before commencement of the divorce. If the child is less than 6 months old, the home state will be the state in which the child was born and lived from birth. Number 2, another state's court does not have jurisdiction or home state of the child or has declined to exercise jurisdiction on the ground that Oregon is the more appropriate court, and 3, the child and the child's parents have a significant connection with Oregon other than mere physical presence, and 4, substantial evidence is available in Oregon concerning the child's care, protection, training, and personal relationships. The type of things the court is looking at in a situation like this is whether there are other family members or non-family members, such as teachers or doctors, who live in Oregon, who have spent time with the child, who have taken care of the child, and who can testify about those things in court at a hearing or trial. So, for example, say spouse A, spouse B, and their child have lived in Oregon for many years. Spouse B leaves with the child to Washington. Oregon is the child's home state and continues to be the home state for 6 months after spouse B leaves with the child. Therefore, spouse A can file a divorce petition in Oregon within the 6 months that spouse B and the child left Oregon for Washington. Once the 6 months pass, Oregon no longer has home state jurisdiction. Spouse A could still file in Oregon, assuming that spouse B hasn't filed in Washington yet, but Washington would have the home state jurisdiction claim over the child and would need to decline exercising their jurisdiction because Oregon is the more appropriate court and the child's parents have a significant connection with Oregon other than mere physical presence, and substantial evidence is available in Oregon concerning the child's care, protection, training, and personal relationships. There is an exception to the requirement of waiting 6 months to attain home state status in the new state. This is called emergency jurisdiction. Emergency jurisdiction is granted if the child is present in Oregon and the child has been abandoned, or it is necessary in an emergency to protect the child because the child or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse. This situation typically comes up when one spouse flees the state with the child and files a restraining order under the Family Abuse Protection Act in the new state. And the third thing you must know before starting your divorce in Oregon is check with the court clerk for a fee waiver. As of the date that I wrote this article, the filing fee for a divorce petition is $301. Once your divorce petition and other initiating forms are ready to be filed with your local county courthouse, you should ask the court clerk for an application to have your court filing fee either waived or deferred. The application will evaluate your income, expenses, and whether you are a recipient of public benefits to determine if you qualify for a waiver or deferral of the filing fee. Whether you are new to Oregon or have lived here for many years and want to start the divorce process, OregonDivorceForms.com has many great options to get you started, including our initiating forms package to file a divorce petition with the court, or our complete forms package that contains all the forms most people need in their divorce case from beginning to end. That concludes the article, The 3 Things You Must Know Before Starting Your Divorce in Oregon. I hope you enjoyed this article, and I hope it helped you understand the divorce process a little bit better.